Hello everyone, welcome to the third episode of Legalese. My name is Washira. On my left, I have the wonderful Miss Nafula, a colleague of mine. On my right, Miss Mbuvi Josephine, very good colleague of mine. And today we're going to discuss two amazing topics on the deed of novation as well as power of attorney. So we hope that we're going to address many of the queries that you may have in regards to these two topics. And we're going to take as little time to ensure that you're well imparted with this kind of knowledge for future use and also in your day-to-day transactions. So we'll start with power of attorney, and I'll start with a very unique scenario. I'll give you a situation where you're not in a position to sign your agreements, you're not in a position to execute or negotiate terms of your agreement. And probably you're in the United States and the transaction is in Kenya. So what do? Do you let go of this transaction? Do you get someone who will do it on your behalf? Do you get someone who will sign papers on your behalf? Because probably this is something that can be done, but because of distance, you're unable to do it. So power of attorney, this topic or this arrangement will now be the premise of the transaction in regards to whatever you need to do here in Kenya, whereas you're in a different country. So Ms. Nafula, what is a power of attorney?
Well, a power of attorney is essentially a legal document that could allow you as Ian donate powers to Josephine, and these powers are going to enable Josephine to be able to do something on your behalf and in your name. So in this case, you as the donating party, you're going to be called a donor or a principal, and Josephine, who's being given the powers to act under the power of attorney, is going to be called a donee. So you could instruct Josephine perhaps to act just in a specific transaction, or you could leave her powers to be broad. Right. And so a power of attorney has to be valid. And for it to be valid, it has to have two elements. The first element that a power of attorney has to have, or rather the person donating powers under a power of attorney has to have, is one, you must be of age of majority. So the age of majority, as we all know, is dictated under the Constitution and the Children Act and the other acts that relate to this particular topic. And in Kenya, as we all know, the age of majority is 18 years. So technically, for you to donate any powers under the power of attorney, you have to be of 18 years and above. And the second thing, or rather the second element that must be constituted in a power of attorney is that the person donating the powers has to be of mental capacity. So essentially, if you are a person of unsound mind, the law does not allow you to donate any powers under the power of attorney. And any powers given under a power of attorney by a person of unsound mind or by a minor, that power of attorney is going to be considered null and void.
So does it mean, let's say you have someone who's drunk or is under lucid moment, does it mean that they can execute this power of attorney? Because is it restricted to persons of unsound mind, or is it that you have that mental incapacity to transact?
Well, that's a good question. And what the law considers is this person, at that point when they were donating the powers under the power of attorney, were they in a state to understand what they were doing? If a person is a person of unsound mind, but at this particular time they were lucid, meaning they were able to understand what it is they were doing and what powers they were donating, then this power of attorney is going to be considered valid. As for drunken persons, the law dictates that because this person is not in a position to understand what they're doing, this particular power of attorney can definitely not be valid.
I agree.
Yes.
we needed to clarify that specific part of it. Yes. So, Josephine, when I do a power of attorney, am I am I obligated, or am I tied down to the actions of the person I'm donating these powers to? Does it mean that whatever he does, I suffer the consequences or I enjoy the benefits of such actions?
So I would say your actions, are your actions as the receiving party of the powers donated and the power of attorney completely, bind whoever gave you those powers, because you are acting on their behalf. So you fully bind whoever gave you the powers, the power of attorney.
Maybe it's important to mention that when you're given powers of attorney, whatever actions you undertake pursuant to this power of attorney has to be in the name of the person who gave you those powers. So Ian cannot give Josephine powers. Then when Josephine is acting, she uses her name. She has to mention that she is doing this particular act on behalf of Ian, who donated those powers of attorney to her.
Okay, so what should I do if I wish to donate powers, for instance, for the purchase of a specific property, and I do not want this person to go and sell my cars, to go and sell my other properties? So what do I need to do to ensure that these powers that I'm donating to this donee are limited or restricted to this particular action or this particular act?
That's very simple, actually. You'll be surprised. The only thing you need to do is issue a specific power of attorney. So we have several types of powers of attorney, and in this particular case, you need to issue a specific power of attorney. So a specific power of attorney describes that particular act that you need the donee to do. So this donee cannot do any other act, but for that particular act, they were instructed to do under a power of attorney. Yeah, so if you wish for the donee to do other acts, you can give them powers of attorney under the general power of attorney. So in this instance, it's going to leave the powers of the donee broad or wide. So the donee can do that act that you're instructing them to do, plus many other acts. Yes.
And do we have a situation where any party to this transaction or any party to this power of attorney can decide that they are no longer bound by the provisions of this power of attorney? Now, as a donor of a power of attorney, the person who's instructing, what do I need to prepare, or what kind of power of attorney do I need to ensure that this other party cannot revoke at any point in the transaction? So what do I need for that?
So you will need an irrevocable power of attorney to do so. Right. An irrevocable power of attorney requires both parties to actually agree that this power of attorney will no longer have legal effect. So, it enables a party, to, not act on, their own volition, just decide that I don't want to be a party to this to this transaction.
Yeah.
Okay. Thank you. As we were discussing this topic, something came across my mind. Now, what if person A decides that they are going to perpetrate a crime, for instance, a fraud? Then when they are presented before court, they are arrested, they are presented before court. Then they decide to, as part of evidence, they present this power of attorney stating that this person in maybe Iran or maybe in the United States gave him these powers to act in regard to this fraud. So can that be a defense? Can you issue a revocable a power of attorney for a crime, for a fraudulent proceeding or fraudulent transaction?
Well, interestingly, the law only allows you to issue a power of attorney in relation to a lawful act. So you cannot give a power of attorney ordering the other person to commit an unlawful act. And also, under our criminal law, there is what we call individual criminality. So every person is held liable for their own criminal acts. So if Josephine committed this particular criminal act, Josephine is going to be liable. However, Ian donating the powers of attorney to Josephine can only be found culpable under the law in what we call conspiracy to commit a crime. Yes.
Right. Okay. Thank you. Now, I have my power of attorney. I have the documents signed by all parties. what else do I need? Does it mean that the person who I've donated these powers to can now proceed, go and transact on my behalf? Is that it? Or what else is needed?
Right. So, to give this document legal effect, it has to be registered. So first of all, you would need that particular document, the power of attorney. It needs to be signed by both parties. And after it has been signed, you need to have it registered under the Registration of Documents Act. So you will need to pay stamp duty for the same. And after paying stamp duty, you will lodge the same with the registrar for registration.
So as we were discussing, I actually remembered something. Throughout our discussion, we've been making reference to individuals, saying Ian can donate to Josephine, or so-and-so can donate to so-and-so. But I'm sure some of our viewers here who are company directors or company owners are wondering, can a company donate powers of attorney?
Yes, most definitely. A company can donate power of attorney through board resolutions. We have specific provisions that guide companies as to decision making, and also how companies can interact with other parties, third parties. So you do a board resolution as a company and you donate powers, and you can also receive powers of attorney as a company. So if it's a company that is donating to you, ask for a board resolution for a company for it to be validly conferred to yourself. Yes.
What about powers of attorney that have been registered in foreign companies, foreign countries, sorry. For instance, I come to Kenya and I want to enforce a power of attorney that was donated to me under the laws of the Republic of Tanzania. Does that power of attorney donated in Tanzania have legal effect in Kenya?
Ms. Mbuvi had described the process of registration of a power of attorney in Kenya, and it will have to go through the same process. So you get the document, you bring it to Kenya, you pay for stamp duty, then you have it registered.
Okay.
Then the document will be franked. Now, franking is now the affixation of the stamp duty, seal on the document. So once that is done, it's duly registered in Kenya and can be enforced in Kenya as in the origin of the power of attorney.
Okay, so we've told our viewers what a power of attorney is, what it entails, the elements, etc., etc. And now I think we've come to that point where we need to tell our viewers how to bring this power of attorney, how to end it, how to terminate it. And I think one of the ways that a power of attorney is terminated is by effluxion of time. You might have mentioned in your power of attorney that this power of attorney will take effect today, the 18th of July, and it's going to be for 1 year. So eventually, essentially after the 1 year period, this power of attorney terminates. The power of attorney could also terminate by completion of the event. If I had told, for example, Josephine to act for me in an agreement for sale, I mean, once the agreement for sale is done, we have executed, everything has taken place, this power of attorney ceases to have any legal effect, because the reason why I was donating those powers has already been done. And also, when you want to terminate a power of attorney, you can easily file a revocation for the power of attorney. So the same way you register a power of attorney, you also need to do a revocation, file it, get it, pay the stamp duty, and once it's registered, the power of attorney you had issued ceases to have any legal effect.
That's true. So once the power of attorney, from what I'm understanding, is that once the power of attorney is registered and is in place, and of course the due process has been followed, it means that this donee, the person who I'm donating to, may execute, if I'm purchasing property, may execute my sale agreement, may execute the transfer documents on my behalf, not in his name, right? And the property gets into my name, right?
Yes.
Okay, thank you. Now, what if I decide that now, since the property has been transferred or is yet to be transferred to my name, and I decide that I'm going to transfer this property, or this property is going to be transferred to my auntie or to my loving mother, is there any recourse for me? Do I need to do a subsequent transfer to this person, to my mom? Or what is my recourse in this case?
Well, you don't really need to do another agreement for sale. If you want to substitute a party who was not a party to the previous agreement for sale, what you need to do is a deed of novation.
All right.
So the deed of novation allows you to bring in a third party to this particular transaction without going through the cumbersome process of doing another agreement for sale.
Okay.
Yes.
Okay, now that deed of novation is a very big term. Now, Miss Mbuvi, would you kindly break it down for me? What is a deed of novation?
So a deed of novation is a legal document that, substitutes one party for another party. So it transfers all the obligations and risks to this new party. Yes.
Okay.
Yes.
Okay.
And I think what's important is to ensure that the deed of novation has certain features. I mean, the first feature, of course, that you would expect in a deed of novation is the clause, the release clause. That is to say that so and so has been released from the obligations under this agreement, and in place of that person, you're bringing in person B to take over those obligations, the risks, and the benefits under the previous agreement for sale. And the second one, of course, is to define the parties. Now, you need to mention and describe which party you are bringing into the transaction. I don't know if I have left out anything else.
So who are the three or four parties? I don't know the number. Who are the three parties to this deed of novation? For instance, I'm purchasing property with Optiven, right? Optiven is the vendor, is the seller. I am the purchaser. I am bringing in my mother to this transaction to substitute me. So who are these parties? The Optiven will still be the vendor, right?
Yes.
Who is my mother?
Your mother will be referred to as the assignee, and you will be referred to as the assigner.
All right.
Yes.
Okay, thank
Yes.
you. So I'm assigning all the responsibilities, all the obligations, as well as my rights to this transaction
Yes.
to my mother.
Yes.
Yes.
Okay.
So you will not be legally responsible anymore under this agreement, but your mother, now taking your place, will be responsible to fulfill all the obligations under that particular agreement.
Okay.
Yes.
That's it. Okay, thank you everyone for listening and tuning into a show. We've had an amazing discussion on the two topics of
Power of attorney
and deed
of
novation.
novation. But before we close, we need to tell our viewers about one of our projects. And today we shall be introducing you to one of our best projects. That's the Garden of Joy project.
Oh, yes.
It's located in Machakos County, and it goes for a cash prize of Kenya shillings 1,495,000 only.
So what does it have? We have water, there's a borehole, we have a water tower. It's very green, very beautiful. We have a park for recreation. We have a volleyball field. We have tracks where you can do your jogging. Then is there anything else we've left from the beautiful?
There's a fence.
Yes.
Yes.
And a very beautiful gate at the site.
Yes.
Yes.
So we encourage you to visit our website, www.optiven.co.ke. You can email us at info@optiven.co.ke for any inquiries about any of our projects, any of the legal obligations that you may have as a purchaser, or possible obligations that you may be getting into. Your rights as a purchaser will be very happy to address your concerns, to address your questions, and of course, partner with you in your investment. Thank you so much. Bye-bye.